Hello, this is Erica Norton, and I'm the founder of Perfect Legal Video. I'm very excited to have with us today Attorney Nicole Reeves Lavallee. She owns a law firm in the Worcester area that handles both family cases and real estate law, and we are very fortunate to have her with us almost every week. Today, we are going to be talking about wills and the distribution hierarchy that occurs when there is no will. So, welcome to the show today, Nicole. Thank you so much for coming.
Thanks for having me.
You are welcome. So, we've done versions of this topic in the past, and it is always fun to talk about because I think it's most people don't have a will. Is that right? What's the percentage now?
It's probably about 50%, unfortunately. Definitely should be a lot less in terms of who doesn't have a will. Um, it's an asset. You need to have it. You have assets. Everyone has assets. Everyone has something that they care for, whether it be a loved one or just personal property. Have that will. Get it done.
No, absolutely. And it's not as difficult as one might think. I mean, it is something that you have to do, and there's a lot of questions that get asked, and it's a little painful of a process, I guess, to try to figure everything out. Because I just remember when we did it, you killed everybody off, and we figure out what the scenario would be if this person was dead and that person was dead, and you can't leave it to somebody in your will, and then, you know, that person no longer exists by the time you die, and then you just didn't go back and change it. So, I mean, it's definitely interesting about how everything works. So, yeah, of those people that don't have a will, and I know that I didn't get around to doing a will until really until I got divorced. And I really should have done it when I had a kid and probably before that as well. But I mean, there are, you know, major life happenings that may just really get somebody to make that move and get the will in there. Um, but sometimes you die before that happens, right? So let's talk about what happens, Nicole, if you die without a will.
You die without a will, then ultimately all of your assets that are not specifically earmarked with the appropriate authorities of a joint holder or distribution upon death, beneficiary upon death type language. So, an individual bank account, vehicles, houses. If you only have one person's name on that and that's yours and you die, then it's going to go to your heirs. The question is, do you even like your heirs? Sometimes the answer is no. And if without a will, the court is going to direct who those assets go to. And again, you don't get to pick because you chose not to draft up a will.
And that is so true. I just remember my grandmother, my Nana, what we called her Nana, she and her brother didn't get along anymore, but I guess she ended up with all of his assets because he died and his wife died. Nobody changed the will. And then she just got it all. And he would be rolling in his grave because they had a lot of bad blood for years. And, that is definitely something we always said. I'm like, oh my gosh, she got everything.
It definitely happens more often than not. There's all too often people do that and they're like, well, no, everyone knows that I'm giving it to so and I'm not giving it to my brother. I hate my brother. Great. He's still your brother. If he happens to fall in the kinship hierarchy, he's going to be the one getting it.
So, what is the hierarchy? Is it just obviously first your spouse, or does your spouse have to split things with your children? I mean, how does that work?
Well, the hierarchy is going to be depending on where you are. So we're going to look at, do you have a spouse? Do you have children? If the answer is, I have a spouse and my children are a product with my spouse, then it's all going to go to my spouse. But if you have a not intact family, then it's going to go half to your children and half to your spouse. Now, what I mean by that is you have children from a previous marriage or a previous relationship. And then you marry husband number two. Husband number two would get 50%, and your children would get the other 50%. And if you have multiple children, those children would get their share of the 50%. Three children would each get 20% or 1/6 of the estate. And that's how it would work.
Well, that's interesting. However, you can avoid that if you want 100% to go to your spouse. It's your second husband or wife. And let's say you've been with them for 20 years and it doesn't even matter if you've put the time in, but some people are married for a year and then there's like huge family fights because um, the parent died and this person that's known them for 5 minutes gets half of the estate. And I mean, I'm sure people fight about that stuff in court, but that's what you're talking about, right?
So, in your scenario, generally, I would agree that you would want to leave it to your spouse if you were married to them for 20 years. But again, if it's not that intact family, that child of yours can ask for their elective share.
Wow, that's interesting. So no matter what your will says, your child can still ask for their share.
Yes, but you can also specifically disinherit your child, which is what you would have to do in that particular circumstance.
But what if you're dead? You can't disinherit them.
You'd have to disinherit them in a will.
Ah, wow. That's harsh.
Sorry, that's the law. If you want to do it, you have to put it in writing. And that's the reason why people do put it in writing. And, this is just one instance. But what if you have, you didn't have children and your spouse predeceased you and he didn't have any children and your parents are dead? The issue is that kinship, like I said, can go anywhere. We're going to be talking about, cousins and siblings and aunts and uncles and all those people. That's where we're going to be looking at, because in Massachusetts, we will find those particular people. And those particular people that maybe you've never even met are the ones that are going to get the money and all of your assets in your estate if you don't leave a proper will.
Wow. So what do you do to protect yourself from that happening?
Well, obviously, create a will, create a trust, have a conversation with an attorney. And I think, the one thing I always tell everyone is look at it every 5 to 10 years. Things are going to change. Circumstances are going to change. Assets are going to change. Maybe you're richer. Maybe you're poorer. Maybe you sold things. These are things that we need to have discussions about. Maybe the person that you left in charge has Alzheimer's and can't function and can't do that role anymore. Maybe they passed away. There's a lot of reasons why we're going to look at those items and attempt to change them because they just don't work anymore. So look at them, revise them accordingly.
And how often should you do it? Do you think every 5 years or when you see a big change?
Either. I think either option is recommended. It really kind of depends on your circumstances. And, then you have the people that have never married, but they had a significant other, a partner in life. Like you said, I've been together with this person for 40 years. That person has no legal entitlement. They're not going to receive a penny unless you designate it. And they're my partner. They're my best friend. Of course I'm leaving it to them. Great. Execute that document.
I mean, yeah, exactly. And what I liked about how you helped me set up my will was that, you did go through all of the different options. And I have a child. So, part of it was, hey, well, what happens to your child? And what happens if you're saying she could go with that person, but then that person can't take her, or, maybe isn't around anymore. Maybe, like you said, mentally incompetent. I mean, there's a lot of stuff that can happen. People can get in an accident and just, they're disabled and they just can't do it. It's just not good for them. So there were lots of options. Well, if she can't do it, then can she do it? And then, and then what are you leaving them to be able to take care of your child? And then it's like the inheritance. What year do you want your child to inherit this? Is it going to be a portion at 21 or 25 and then they get the rest at 30, or when they're more responsible? I mean, there's a lot of tiers and a lot of layers to how you set that will up. And I just really love how well thought out that is.
Well, you have to be. I mean, the reality is, unfortunately, we've seen all of these things happen. I'm not creating something new. I'm not, giving you scenarios that I haven't seen before. Unfortunately, our job is to plan for the worst. So we do have to run through a lot of scenarios because every scenario may change your outlook. Oh, I didn't think about that. What if, again, you go back to, I really love my sister-in-law. I really don't like my brother, though. Okay, well, guess what? They're a unit. And, you're going to be tied to that unit, whether it be because they're going to be the personal representative or the guardian. You have to understand that they're a unit right now, and maybe they will get divorced. But today, do you want that situation? Oh, well, no, I only want it if my brother's gone. Well, then that scenario doesn't work. So we have to run through things like that because you're planning or going, well, I want this earmark specifically for. Again, they're a family unit. You can tell me all you want, but at the end of the day, you know as well as I do, husband and wife are going to be sharing that. So we really want to open your eyes, and that's our job, to open your eyes to these possibilities for you to make better educated decisions.
Absolutely. So don't try to set up your will alone. I mean, I'm sure that there are documents online that you can find. I mean, that's really not going to keep you up to date with all the different things that can go wrong. I mean, those are just boilerplate, very generic. And if there's one thing about, people preparing their will is that there really is, not a same scenario for everyone. Am I right about that?
You absolutely are right. And, again, it's just one of those things that unfortunately, us passing away is inevitable. So we really need to make sure that we're doing something that we're protecting these assets that we've, nurtured for so long.
And I think these are all really great points, and I hope that people will beware of not having a will now, and even maybe they just try to doctor one up themselves. You can have a professional look at it, and they can make sure that it's where it needs to be to actually hold up in court, because you might have something that's just not going to hold up, and that's the one thing that you really want because you won't be there to fight for yourself. So definitely give Nicole and her team a call if you do have questions about putting together your will, or maybe redoing a will that was maybe kind of done on the fly, or maybe it just needs to be looked at again because it's been a little while, or circumstances have changed. So we really appreciate your coming on today and giving us this information, Nicole, as always.
Absolutely.
Thank you so much, Nicole, and thank you so much, everyone, for watching. We will look forward to seeing you next week.